Sharing my screen, and I'm opening the webinar. We're just going to pause for 30 seconds. So opening the webinar. And you're welcome to get started.
Good afternoon, everyone. My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar Association, and want to welcome everyone who's joining us today. Glad to have you with us. As you know, our program today is last year's significant cases handed down by courts in California regarding real estate. I want to let you know about some of our upcoming programs. Next month, we will have someone from the California Association of Realtors joining us, Jana Gardner, who has assisted us as well the last couple of years, talking about new forms or changes to existing forms that CAR uses, since those are the predominant contracts used in residential transactions and sometimes also in commercial. We're then going to do a new program that we've never done on short-term rentals, things like Airbnb, hopefully with an emphasis on some of the restrictions in our local jurisdictions around Los Angeles. We'll do a property tax program we anticipate in June. In July, we'll do also something new, which is a program looking at some of the new state laws that are restricting local zoning and that are going to allow a lot more development and that may not be within the discretion of our cities, and how that may affect residential and commercial construction. And in September, we're planning a program on land use. For today's program, we'll be using the Q&A for questions. I'll try to monitor that, and to the extent we have time, we'll take questions, and those will go in Q&A and not chat. We are very, very happy to have with us again this year Lawrence Jacobson to talk about last year's important real estate cases. Larry also does this program with a panel for CEB. Larry's a double graduate of UCLA, both undergrad and law school. He was a senior editor of the UCLA Law Review and graduated as a member of Order of the Coif from UCLA Law. He's a past president of this bar association, the Beverly Hills Bar Association, and has a long history with our real estate section. In his over 5 decades of practice, Larry has extensive experience in real estate and business matters, including business entity formation and restructuring, purchases and sales of businesses, succession planning, purchase, sale, management, and refinance of commercial and residential real estate, and tax-free exchanges. He's testified numerous times as an expert witness in cases involving interpretation of real estate documents, real estate and mortgage brokers' standard of care, and legal malpractice involving real estate, and also in matters of corporate finance, mergers and acquisitions, legal ethics, and fee disputes. Larry has written and lectured extensively on business, real estate, and ethics-related matters. He's taught for the USC Broker Development Program and Graduate Realtors Institute of the California Association of Realtors, and he's lectured for, as I mentioned, for CEB, and received their Spirit of CEB Award in 2011. Larry has served as a judge pro tem for LA and for the Beverly Hills Municipal Court Systems. He's an adjunct professor of law in the area of real estate, secured transactions, and administrative law. And he was deputy special trial counsel for the State Bar of California. He's a contributing author to California Continuing Education of the Bar 2-volume treatise, The California Real Estate Brokers, Law and Litigation, former vice president of legal affairs for CAR, legal counsel to the Beverly Hills Board of Realtors, the San Fernando Valley Board of Realtors, and California counsel to an international real estate brokerage firm. Currently, Larry is legal counsel to the Newport Beach Association of Realtors and a member of the California State Bar Real Estate Sales and Brokerage Steering Committee. And Larry, thank you for being with us, and the program is yours.
Thank you, Howard. After an introduction like that, I can't wait to hear what I have to say. When Howard was listing the upcoming programs, it allowed me to save more time for some of the other cases. I originally was going to discuss the new CAR purchase agreement, bemoaning the fact that I couldn't provide you with copies of the form itself because of copyright and the amount of time it would take to talk about it. But since we've got an upcoming 1-hour program next month, I strongly encourage you to go see it because it will answer many of the suggestions I was going to have in regard to the form, which is to acquaint yourself with it. Just briefly touching, I'm not going to go over the minor changes that occur in the body of the document. I'll just focus on the major change, which makes the form look very, very different, but which really isn't a change. It's more like they added an index. One of the problems with the residential purchase agreement, if you ever had occasion to run across it, is the deal points are scattered through the document. You know, they'll have the price on one page and the deposit on a different paragraph, and then you have a time for approvals. So every time you want to look at the agreement to find out what your obligation is, you got to spend about 20 minutes leafing through it till you can find the appropriate section. You don't have to do that anymore. On the first couple of pages, they've added a quote new paragraph, although it's actually longer than that, which lists all of the material deal terms. In other words, what goes into all the blanks that appear throughout the agreement, so that you fill them in there. And there's a cross-reference to the paragraph in the agreement that explains how it works. So if you have a question as to what happens if the if the buyer hasn't responded timely on the contingency, you'll see the number of days he has, you'll see the cross-reference, and you can, it's much easier to find it. It's like doing something to Miller and Starr. You start with the index.
Larry, I have a comment, if I might. We went over that new form with Jana Gardner last year, and I would caution everyone that what CAR has done is during this long period of time when it was a seller's market and buyers were having to agree to just about anything, the CAR went in their form and took all of these new realities of that tight real estate market and put them in the form, so that the form is now, in my view, much less buyer friendly, much more broker and seller friendly, and was created for that tight real estate market. Now that interest rates are higher, things are loosening up somewhat and probably are going to become more of a neutral market or even a buyer's market. If you have a chance to review one of these contracts before it gets signed, you may want to alter a number of things in there to favor the buyer when you go through it. A number of things which used to be presumed in Southern California, such as the seller pays for certain things, they changed it and just put in a box, and now you can have either party paying that, which has put, of course, the buyers at a disadvantage on things where they used to not have to negotiate it because it was standard practice in Southern California that the seller paid for certain things. So don't be hesitant to go in and try to amend these forms, which are now really, in my view, not very buyer friendly. Thank you, Larry.
First case I'd like to discuss involves multiple listing services and pocket listings. And in the world of the National Association of Realtors, this is a very scary case. Case is PLS.com versus the National Association of Realtors and a series of multiple listing services, including the California Regional Multiple Listing Service. For those of you who may not be that familiar with multiple listing services, is a device in which real estate agents submit their listings, so they're exposed to anyone who belongs to the MLS, which increases the market of potential buyers. Real estate agents who primarily represent buyers think that's a great idea because it allows them access to everyone else's listings. And typically it's considered in the best interest of the seller to put it in there, because exactly for that, they're exposed to more potential buyers. And in fact, if the listing agent is not going to put it into the MLS, there's a CAR form advising the seller of all the advantages of the MLS, just to make sure he's aware of what he's not getting. A lot of real estate agents engage in something called a pocket listing. That's where they get a listing and they drag their heels putting it into the MLS so that they have basically an exclusive on it for a little while. It's especially favored by large brokerages, because Coldwell Banker, companies like that are very large, and they'll of course advertise the listing among their own agents. So they're giving all of their agents an opportunity to get it first, which means that Coldwell Banker gets both sides of the commission. So they're not as thrilled with this. Some sellers, especially high-end sellers, are also not too thrilled with it because of the amount of information that an agent is required to give when he submits the listing to the MLS. So if Jennifer Aniston is buying a new home, she may not want the world to know that she's selling hers. She may not be anxious to have the price advertised. She's not as thrilled to put it in to the MLS and doesn't want it to be. She doesn't mind exposing the property, but without the things that are confidential disclosed. And when an agent submits a listing into the MLS, he has to disclose all that. Well, someone got the bright idea of having an alternate MLS, an MLS that will give you discretion as to what you say about the property and what you don't. PLS. The NAR was very disturbed about this because they felt it was a threat to the traditional MLS. So they passed new rules to be adopted by each of the local MLSs, which had severe sanctions if you didn't submit a listing conforming to their rules, which means you either had to use the PLS, which is more limited in what it's exposed to, or you can refuse to put it in the MLS, in which case you had very large monetary sanctions. PLS filed an antitrust lawsuit a year or two ago and asserted that this effectively was a restraint of trade. And without spending a lot of time going into the details of the thing and discussion of the various antitrust principles involved, at the trial level, the district court affirmed the demur, and CAR, of course, was ecstatic, saying, well, this case has gone away. Wasn't really a threat. I read the complaint, and I read the list of very high-profile, large law firms representing the plaintiff. This was some sole practitioner in Arcadia filing his first antitrust suit ever. These guys knew what they were doing. I said, I think they make a claim. The Court of Appeals overturned that decision and said, yeah, they did make a claim. So they sent it back down to be tried. The consequences of NAR and these regional MLSs losing the case is catastrophic in terms of the amount of damages. Internally, they don't want this. They want to as common knowledge, but internally, they're talking about what happens if we have to bankrupt some of these things. NAR certainly has a deep enough pocket, but the MLSs may not. So, if in fact an adverse judgment is brought down, it'll really shake up the way multiple listing services work, and there'll be kind of a sea change in that. So, one of the interesting things, even if you aren't interested in the MLSs, if you have any interest at all in antitrust, you're going to want to look, because there's a very good discussion in the case about the difference between a per se violation and a rule of reason approach. Next case is Sheen versus Wells Fargo. In the area of loan modifications, it's a very, very significant decision. In the years past, for those of you who attended these regularly, there's usually one or two cases that always involve whether the lender has a duty or doesn't have a duty when handling a loan modification for a borrower. And there's been a split of authority. Site alignment. The cases that held that lenders had no duty, it's a case called NYMAC, NYMAK. I can find it in the C discussions, I'll give you the site. Which held that there was no fiduciary duty between a lender and a borrower. So therefore, if the lender sat on the loan modification, asked for the same documents 7 or 8 times, or in general, handle it like a jerk, as much as it would gall you reading the facts, there was no cause of action because they know the duty. The other line of cases looked at NYMAC, said NYMAC involves the relationship between a lender and a borrower at the time the loan is made. At that time, we agree there's no fiduciary duty. But after the loan is made, that changes the relationship of the parties. And relying on a case called Biancanja versus Irving, a 1958 case, 49 Cal 2nd, 647. In that case, for those of you who don't remember from your days in law school, this was a case in which someone was preparing a will, and he wanted to make sure that it was properly prepared and lawful. So he went to the appropriate person to make that decision, a notary. And the notary looked at it and said, fine and form, but in order to absolutely make sure it's enforceable, I'll notarize it. Not surprisingly, it was not admitted to probate because it wasn't witnessed, which was a disappointment to someone who under that will was a major beneficiary. And now, since it was going without a will, it's distributed under the laws of intestate succession, in which case this guy got far less. That was Mr. Biancanja. So he sued the notary, Mr. Irving, and he said, look, although we didn't have a face-to-face relationship, I'm a third party, and you screwed me out of a substantial inheritance. unlawful practice of law, and your negligence caused me damages. And those damages were foreseeable because you should have known that you weren't qualified to handle this. So this case was heavily relied upon by law firms representing borrowers who felt they were screwed in the modification process. And a fair number of cases followed Biancongi versus Irving. So there was a split in the California appellate courts. This case, a Supreme Court decision, resolves that split of authority and basically gives us one rule, which is NYMAC rules, Biancongi versus Irving doesn't really apply. First place, Biancongi versus Irving involved a third party seeking to recover damages for something that was caused as a result of a relationship between two other parties. This is still a relationship between the borrower and the lender. Therefore, we can, Biancongi doesn't really apply, and NYMARC will control, and NYMARC says there is no fiduciary duty, which makes life a lot more difficult. Here it is. NYMARC versus Hart Federal Savings, 231 Calap 3rd, 1089, 1991 case. Going to make it a lot harder for lawyers who are representing borrowers who are screwed in the process from finding a viable cause of action. Next case is Barkley versus Boskowski, Ninth Circuit Court of Appeals case. As we all know, under California law, you have certain exemptions that you can file so that you have something left after the creditors pick their bones. And the bankruptcy court protects that right. It says if you're in bankruptcy, you have a right to the state law protection. In this case, the debtor bought a home. Several years later went bankrupt. And a funny thing happened between the date he bought the property and the date he filed for bankruptcy. The exemption was raised. And the question was, what exemption is he entitled to? The one when he bought the property, or the higher exemption when he declared bankruptcy? This court case held under their interpretation of the bankruptcy code, unless the Supreme Court overruled it, they held he gets the higher one. We talk about co-tenancy provisions. We're not talking about the co-tenancy between an unmarried couple who buys a home, deciding how they handle it, or where several couples buy a vacation home. It's not that kind of tenancy in common that we're talking about. This is the one involving shopping centers. They're sometimes called co-tenancy agreements, sometimes operating co-tenancy agreements. What they are is an agreement between the tenant, a new tenant, and the shopping center, saying, after I've agreed to all these egregious terms in your lease, I want a couple of exceptions. Shopping center's still under construction. I want to reduce rent until you're done. I'm relying on foot traffic of people going to see all of the tenants. If you have two anchor tenants, one at each end of the center, you're gonna have a lot of pedestrian flow, and they'll pass my place and they'll take a look and say, maybe I'll look in there. So if you haven't reached at least, let's say, 80% occupancy, I'm not going to get that. So I'm going to get reduced rent getting that. Then you have the force majeure thing. What happens during COVID and all that stuff. So the question is, whether or not these agreements were enforceable. You know, for a tenant of the West Side Pavilion, what do you do if Nordstrom's and Macy's is gone? Moot now because they closed it. In JJD HOV Elk Grove versus Joann's Stores, the court explains, explores the question about whether co-tenancy clauses in real estate leases are enforceable. And they held, they did, that a co-tenancy agreement is not a penalty clause in terms of alternate performance. It's not considered a breach by the landlord. It's considered a provision in the lease that is operative on certain circumstances. It would only be a breach if the landlord refused to honor the agreement. But the agreement itself is enforceable. Next, we're going to talk about something called STR licenses. STRs, short-term rentals. Case called Hobbs versus the City of Pacific Grove. And this usually applies to the area of condominium developments. We've got a lot of people who live in the condominium. The condominium is their primary residence. They want a nice community filled with homeowners and pride of ownership and all that. Nice set of CC&Rs to keep everything on an even keel. But some people either decided to move out of their condo and move up, or they inherited it from someone, decided, well, I don't really want to live there, but I don't want to sell it because it's a decent investment. The value is going up. So I'll lease it. Well, it's one thing to lease it out for a year or 2 years. You've got kind of a stable ongoing tenant, but short-term rentals became popular. You're in a nice vacation area, so you do a 3-month lease during the summer, things like that. Well, those kind of tenants are not the kind of tenants that the people who live in the center are really thrilled with. So they're not happy with it. And in fact, in last year's program, I talked about a case that discussed what happens when the homeowners association CC&Rs are amended to preclude it and when they can or can't. In this case, the City of Pacific Grove started granting licenses for short-term rentals. And the licenses, in this case, in the Hobbs case, a year later came up for renewal, and the city said, well, we're not going to renew it. We've already reached the maximum percentage that we want to see in that condominium project. So Hobbs sued said, well, you can't do that. It's a denial of due process. So the court had to determine whether or not these STRs were a vested right or not. And they said, no, they're not. Case that discusses the difference between the municipality to regulate high rent rate increases and Costa-Hawkins. It's called Costa-Hawkins Rental House, San Francisco Apartment Association versus City and County of San Francisco. In this case, the City of San Francisco is looking at the circumstance of apartments that were not subject to Costa-Hawkins for one reason or another. They were not subject to rent control. And under Costa-Hawkins, the city couldn't impose rent control. But when leases came up for renewal and the landlord wanted to get rid of the tenant, he had to offer to renew the lease, but he'd do it at triple the rent. So the question, the court has to consider, this ordinance, which prevents that from happening, whether that is a rent control ordinance subject to Costa-Hawkins, in which case it could not be enforced, but rather was the city's attempt to thwart bad faith efforts to circumvent the city's lawful restrictions on the right to evict residential tenants, where the city can't regulate those units. And the court held that it was enforceable. It was not, did not conflict with Costa-Hawkins. Next is a case called Fernanda versus Middle Fork Ranch Incorporated. So although Middle Fork was an Idaho corporation, it was in the Ninth Circuit. Group of mountain vacation cabins. And during a period of time when the cabin was not occupied, it caught fire. It burnt to the ground. And the question was, what caused the fire? Was it negligence on the part of the Middle Fork Ranch, which basically managed the complex, or some other cause? Who got to pay the bill? Well, the plaintiff hired an expert, Michael Koster, who, based on his qualifications, was a very, very well qualified expert. And he examined it and said, from what I've seen and what I've investigated, it appears that one of the workers for the homeowners association was applying this new oil substance to the flooring. And a spark hit it and caused the fire. Therefore, the homeowners association was responsible. And the expert testimony was challenged because he was giving an opinion as to how the fire was caused, which is the ultimate fact to be determined by the court, basing it not on real evidence that was introduced, but based on his analysis. And what I would, as an expert witness, consider a close call. The court held that the evidence was admissible because the techniques used were very careful, consistent, and would be helpful in letting the jury make the eventual decision. And the fact that his conclusion was that the homeowners association was responsible really wasn't his call. It's the jury's call, but within the context of the opinion would be allowed.
Larry, do you have the citation for that case?
It's, you guys should have my citation list.
I do, but I see. Yeah.
Okay.
26 F4 1017.
Next case is Hoffman versus Young, Court of Appeals case. In this case, the defendant owned a large piece of property on which the residence was, but it was very rural. It was a place where you're surrounded by lots of open space, which is great for what do they call it when you're off-roading with a motorcycle. In any event, their adult son who lived with them invited a young lady, plaintiff, motorbiking, to go motorbiking with him. And she suffered horrendous injuries. I mean, life-altering injuries. And she sued the defendants, arguing that as the owners of the property, they did not give her appropriate warnings. But you don't have to give appropriate warnings when the person's on the property without your permission. So the question was, Was the adult son's inviter on the property permission granted by the parent owners? The court said there was nothing in the record that would indicate that the son was given that authority. And without that authority, permission wasn't granted by the owner. In the interest of time, and skip over Romero versus She. That case upholds the creation of an equitable easement in favor of an encroaching neighbor. That may be something, Howard, you'll want to look at. Howard's my go-to guy in neighborhood disputes.
That case I thought was notable because the easement that they allowed the court to impose as a matter of equity covered a very significant part of the property. It was almost, I think, 1,300 square feet out of 9,000. And the issue also in that case about whether or not there was the encroaching party was acting in good faith and not negligently or otherwise looked somewhat debatable. But they still allowed a very significant easement to exist, granted basically solely by under equity by the court.
There goes the time I was going to save by not discussing it, but it was a very good summary of it. Next case, Siri versus Saeed. There's about a 0 chance I'll pronounce this right. Farkhandepur is a very interesting case, which adds a rather new and very sharp arrow into your quiver of remedies. There is a provision of the California Penal Code, section 496C, dealing with penal penalties for receiving stolen property. The court can basically hit them with treble damages in a criminal lawsuit. Well, what happens when you're in a civil lawsuit? One usually doesn't seek triple damage remedy based on a criminal statute, but this case said, yes, you can. So let's say a typical real estate transaction where there's really serious fraud involved. You might consider looking at some of the criminal statutes that affect it. And for those that allow you to recover treble damages, you might want to consider a cause of action in that. Threat of triple damages may very well assist you in something in the case.
Siri was closely watched by a lot of people because it does open up treble damages and attorney's fees, and it did so by using the broadest, really, I think, definition of theft that you find in the penal code, not the narrow definition that some people might have thought was appropriate. So it's potentially going to be something we see a lot of in lawsuits.
Got about less than 25 minutes left, so let's see if we can get through these. Grief versus grief. Excuse me. Grief versus the Yardley Protective Limited Partnership. Let's cross-complain that. This case explored the duty owed by an agent who represents solely the buyer, what duty he owes to the seller. Now, we all know that an agent who represents the seller owes a fiduciary duty to the seller. Those of us who practice in this area know that the duty owed to a party to the transaction who is not represented by the agent is not a fiduciary duty, but is good faith and fair dealing. The question is how far that goes. In this case, we've got an elderly seller who's mentally impaired, hearing impaired. Who wants to sell the property that he bought for $1,850,000 several years ago. And they're talking about selling it for something in excess of $3 million. The discussions range from $3,399,000 to $3,380,000. And they finally agree on a purchase price of $3,330,000. But due to the seller's poor hearing, speech impediment, and cognitive issues, it's possible the buyers didn't understand the exact numbers. As a result, the purchase agreement provided for a purchase price of $330,000, one decimal off. This was clearly well below the true value of the property, something which the agent representing the borrower would clearly be, the buyer would clearly be expected to know. The court said that under the duty of good faith and fair dealing, this was not something that he had to tell the seller. He didn't deceive the seller. His buyers misunderstood what the purchase price was because of the hearing and speech problems. They really thought they were buying for $330,000. So he had no obligation to say, okay, you're selling this property for $330,000. I just want you to know it's 10 times more value. He doesn't have that obligation. He doesn't have to get involved if he's representing an agent, like if he's representing a buyer who's buying something at a steep discount. He doesn't have to counsel a party who's not his agent. Quash, this is California Commerce Club, involves when you waive the right to arbitration. In this case, they filed a lawsuit. They conducted extensive discovery. But in this case, the court held that that alone didn't take away your right to compel arbitration downstream. The amount of discovery taken was not so onerous that it was an attempt to get around the discovery rights under arbitration. Nunez versus City of Redondo Beach. Lady was coming back from a marathon, local run. After it was over, she was walking back and she tripped on the sidewalk, because where the two pieces come together, there was a slight raise. And the question was the liability of the city. And it turned on the question of whether this defect was trivial or not. And the sort of expert testimony. We have a trip and fall case. We want to look at that. Nunez versus Patel. This was a case in which seller sold his property, was to get a lease back. It required the buyer to do certain things. They signed their deal. As documents were being signed, the Patels gave the seller the lease to sign. But they didn't tell him that this was not the lease that he reviewed. This was another lease with far more onerous terms, which the seller found out after the deal closed. And the question was who was liable for the fraud? And the question of where the buyer's bad acts would be attributed to. They were, of course, responsible, but the entity that was the buyer was an entity they controlled. So the court discusses when the liability follows. Crescent Capital Holdings versus Motives Investments deals with a foreclosure process and what happens when you're doing a foreclosure when there is somebody living on the property and you don't include that person in your notice of foreclosure. There is a provision in the law in which you can add a tenant to the cause of action post-judgment if he had no valid right to be on the property. Here the tenant asserted he was on the property and should have gotten notice, and the court held that yes, you were on the property, but you didn't have a valid claim of right. Gallo versus Wood Ranch. The Wood Ranch is the barbecue place. Gallo was hired as a server. When she was hired, she signed an employment agreement which required arbitration. She was terminated. She felt she was terminated for the wrong reasons, discrimination, etc. So Wood Ranch insisted that it be arbitrated. Gallo paid her charges as required. Wood Ranch didn't. So the arbitration is kind of in limbo. After several attempts, it was clear Wood Ranch was not going to pay the arbitration fee. So Gallo moved to have the court, which ordered the arbitration, to reverse its order so she could proceed without arbitration. And Wood Ranch said, well, he did have the authority to do that. At the end of the road, the court said, the appellate court said that yes, the trial court did have the authority to do that. Otherwise, she's not going to have a remedy. She's required to arbitrate, and the other side is sitting. The last case, Montez versus Young Men's Christian Association of Glendale. It's a personal injury case. The young man lived in the YMCA building. He was having a very good time. Spent the night drinking. He topped it off with eating a marijuana brownie. Not surprisingly, it was high as a kite. Now, the roof of the building was sloped at a steep angle and was covered with brittle, broken, slippery, unstable tiles. It was an open and obvious risk. The court agreed that there was no need for the plaintiffs agreed that there was no need for their son to be on the roof. Needless to say, the reason why the plaintiffs were suing was the son fell off the roof. The court held the YMCA owed no duty of care to the son. Court said that the YMCA owed no duty to do anything to protect the son from his voluntary, unnecessary, and uninvited risk-taking. So that wraps it up. If you have any questions from the 4 hours.
I don't have any questions in the Q&A. Since we have a couple minutes, I would mention on sort of a different aspect of number 17 on the arbitration, the Gallo versus Wood Ranch, where Wood Ranch sought the arbitration but then didn't pay. I have had opportunity to research what happens if you ordered arbitration and party says, I can't afford to pay. And unless the other party who sought the arbitration pays for them, there is some authority that says that you don't have to stay in arbitration. And if it goes back to the court will have to hear the case, which was sort of a surprising bit of law, I thought, when researching that. But even if you're ordered in arbitration as a plaintiff, if you can't afford it and the other side isn't going to pay, you may be able to go back into the court and not have to worry about the arbitration. And again, there's always some interesting things like that that we run into that are unexpected when you actually do the research on them.
If you can't afford to pay the arbitration fee, then hopefully your attorney is working on a contingency fee basis, because if he's working on hourly, 2 hours in will have covered the fee easy.
That's the lawyer's dilemma in life. At any rate, we've concluded a tiny bit early today, which of course is not the most common thing for our programs, but I want to thank Larry very much for presenting this again this year for us. I want to thank everybody for attending, and I look forward to having you attend again next month for our CAR forms presentation. Then after that, the other programs I mentioned at the beginning of the session today.
When I do this program again, the Pasadena Bar Association, I can discuss in detail the course of the cases I skipped over. Didn't realize we were going quite that fast.
Yeah, I think the list was a little bit shorter, and some of them, didn't merit a lot of discussion this year. But want to thank everybody and thank Larry for the presentation again. And thank you everybody for attending.